Hello everyone, it's Wayne Jones, the course coordinator for Statutory Interpretation. We're up to week 8 and I want to talk to you about extrinsic materials. Now, we've spent a couple of weeks on intrinsic materials, and they were the materials, of course, which are within the Act itself. So just as a brief reminder, we looked at two aspects to that. We considered the structure of the Act and where we might go for help to look for how to interpret a piece of legislation. That included things like making sure you looked to see whether there was an interpretation section or even a dictionary in the Act. And we thought about things like long titles to the Act that give us a clue as to what the purpose and the object of the legislation is. Now then, the second matter that we looked at with respect to intrinsic legislation was the words themselves, and we looked at some of the words that have fairly common meanings, and that included meanings that are given to them by the interpretation legislation. So this week we're looking at Chapter 8 in the Statutory Interpretation book by Michelle Sanson, and as ever, just make sure you have a read through, but think about these main points as you're working your way through. Well, what are extrinsic materials for a start? Now, they are those things which are outside of the Act itself. So, as I said before, consider where we've been in the last 2 weeks with intrinsic. Now, these are extrinsic things, things which are outside of the black letter law, outside of the piece of legislation. Why do we do that? Well, you might recall this case from a couple of weeks ago, the CIC insurance case, Bankstown Football Club. But the point and the statement made by the judges in that case that's referred to in your text is this: that when we have a modern approach to statutory interpretation, we consider the context first and foremost. So we don't wait for something to be ambiguous. That the direction that we're given now by the courts is to always be thinking about what the context of the legislation is. And I think that we said when we looked at context that that's how we tend to read anyway. We don't read individual words in isolation, and even when we read a chapter, it's a chapter out of a book, so we think about the context that it's in. The CIC case, of course, the judges also said that context is to be given its widest meaning, and that sometimes includes things which include, for example, the history of the legislation itself. Another reason is that the statutory rules themselves in section 15AB of the Commonwealth legislation say that we can use extrinsic material in the interpretation of the Act in these circumstances. Now, broadly they are to confirm that the meaning is the ordinary meaning, and we'll talk about that a little bit later on, but also to work out the meaning when the provision's ambiguous or obscure, or the ordinary meaning conveyed by the text is going to lead to a result that's manifestly absurd or unreasonable. Now, there's quite a list of material in the legislation, but that list is not exhaustive, and if I could ask you to have a look at that list, think about some of the things that appear on here, but just as equally think about some of the stuff that's not on here. And the two big ticket items, of course, are you won't see in the list a reference to previous case law where the meaning of the legislation has been worked out, nor will you see a reference to a dictionary. Now, here are some of the examples from that list. You should be looking at the explanatory memorandum, or you can look at the explanatory memorandum. That's the document which goes in when the new bill is introduced, and it's written by the Minister, providing an explanation of what it is that the bill is trying to achieve. Now, just on explanatory memorandum, I've made a note there about Hansard, sometimes called record of proceedings. They're not the same thing. I've had a couple of questions about this, and they're not exactly the same thing. The explanatory memorandum, as I said, is the document which accompanies the bill. It's usually been written by the Minister's office, so it's it's meant to be an easy to read explanation, and I've given you an example in the notes to have a look at for some recent changes to Queensland legislation. So it's a good practice, I think. It's been around for a few years now to put in this explanatory memorandum to talk about what the bill's all about. But it's not Hansard. Hansard is in fact the record or the transcript of the proceedings in the Parliament itself. An example that's given in the textbook of explanatory memorandum being used is Edwards against Santos Limited, and that was where the court was talking about how Indigenous land use agreements, or ILUAs, came into being, and to put them into context, the court looked at the explanatory memorandum. Hansard, that I mentioned before, is what we're talking about when we talk about the second reading speech, and it can also be looked at by the courts from time to time. So it's the record of what happened in the Parliament. If you think about it this way, court proceedings are all recorded. Similarly, the proceedings of Parliament are recorded, and you can go on to the Search Hansard site. I think this extract here is from the Queensland version, but there's a similar thing in most states and territories, and there's certainly this similar search facility with the Commonwealth Parliament. An example from the textbook again, Re Bolton, ex parte Bean. This is the deserter case where the fellow had been a deserter for more than 20 years. To try and work out a meaning there, court was quite happy to have a look at the second reading speech where the minister who introduced the legislation talked about what the intention, or his intention, was in introducing that bill. Law Reform Commission reports. You will, I suppose one of the points to be made about Law Reform Commission reports is they're not, the commissions themselves aren't part of the court system, they're part of the executive arm of government, so they usually report to the Attorney General, but they're set up, and most states and territories and the Commonwealth now have a permanent Law Reform Commission that's always doing this work, that's always looking at reform to law. And the suggestion from the text is you can go to a Law Reform Commission report and see what the reformers had in mind so far as changing the legislation was concerned. In Spence against the Commonwealth of Australia, an example given in your textbook, the Australian Law Reform Commission made some recommendations on how to conduct migration cases, and I think from memory what they were looking at was the large number of appeals, or just the volume of litigation that was going through the courts, often said to be with a view to simply delaying what was a pretty inevitable day when a person was going to be repatriated. It introduced, from memory, I think they introduced a concept of being able to, or the Commonwealth being able to apply for a summary judgment where they could put the material before the court and have a summary judgment on the matter. But again, in that case, the textbook authors give you Spencer and the Commonwealth as an example of courts being happy to go and have a look at a second reading speech regarding the introduction of the Reform Bill to see what was on the Minister's mind. International treaties, again there's a database. This is an extract from the Australian Government DFAT page where you can click on and search the online database of these treaties, and I think you should. It's probably worth your while to have a look and see what sort of treaties are out there. The interesting thing about treaties is the limitation on their use. So the textbook authors are suggesting to you that when legislation gives effect to an international treaty, so you've got an act which brings in a treaty, the court can look at the treaty to resolve any ambiguity in the legislation, but there's some limitations to it, because remember, often these treaties are enacted overseas under different jurisdictions. So the textbook authors, I think, are just making the point quite validly that they might have some limited use because they haven't been, the treaties themselves haven't been produced in the Australian legal system. So you look to the Vienna Convention on the law of treaties, but you're certainly not looking to Australian legislation to interpret the treaty. You are looking at Australian legislation to interpret the enabling legislation. Have a look at the textbook on that point and just Just get that clear in your mind. Look, the big issue for me, though, I think everything's pretty straightforward, but the big issue to take home out of week 8 is really about what some of the limitations are on the use of this extrinsic material. So we've probably got to the point where, and I'll finish on this as well, but we've probably got to the point where it's accepted that counsel acting for the parties will bring forward extrinsic material to help the court to follow their line of argument about how a piece of legislation should be interpreted. But there's still some, I think, quite important limitations on its use. Now, in the Bolton ex parte Bean case, it's interesting to notice from the extract in the textbook even that the speech that was given in the introduction of the legislation was pretty clear. The minister who was introducing the legislation at the time was fairly clear in his view of the world, and really he was saying, oh well, the purpose is to catch everybody, not just people who are here with visiting forces. Now this is the Bolton case was given in your textbook at 145, 146 and 147, and I'm bringing it to your attention because it's a good example of limitation. Now one of the limitations being, if that speech is at odds with the legislation, then as it is subsequently enacted, then the extrinsic material can't redeem a failure to translate that intention. It can only go so far. So I think that's a really important point. In other words, you can't use the extrinsic material to give a very unnatural meaning to the words. If the meaning is very clear from the legislation, then the extrinsic material can't cure that problem. So I think that's a really good point to make. I'm looking at the text. I think I've extracted it here. Standing as a warning that extrinsic material won't necessarily redeem a failure to translate the intention of Parliament into the text of the law. So it can really only go so far. It's always going to be very important to remember that, because you might, for example, have a problem where the temptation is there to go and have a look at the extrinsic material. You think you've met one of the triggers. You might be saying that the ordinary meaning is still somewhat obscure, or there are a number of possible meanings, so there's some ambiguity. All right, well, you've ticked that box. Now, when you go to the extrinsic material, just remember Bolton. There's only so far that you can go, because if it is reasonably clear as to what's not included, then extrinsic material can't help. Look at the Act itself, and the text makes a bit out of this as well, and talks about the language of the Act in section 15. The Act itself says that extrinsic material is there firstly to confirm the ordinary meaning. Now there's some to and fro over that. I'll leave you to read that in the text as to, well, does that mean you can only confirm, which wouldn't make a lot of common sense. Clearly it would mean that you can confirm the ordinary meaning or confirm that some other meaning is possible and more likely. Remember, it's bearing in mind, it's not just confirm the ordinary meaning, it's confirm the ordinary meaning taking into account context and purpose. So the Act itself says you've got to go through that first of all, or you can certainly do it where the legislation is ambiguous or obscure or manifestly unreasonable. So your first argument is always going to be, if you're wanting to use extraneous material, is the easiest one, which is that, well, Your Honour, this material is ambiguous. There could be a couple of possible meanings, or the meaning might have changed over years, whatever it's going to be, or the meaning's a bit obscure, or we've come up with a result using the ordinary meaning, which is it's manifestly unreasonable. But manifestly unreasonable doesn't mean that it doesn't meet your case. It means that it's coming up with an absurd result. So, another limitation that you need to think about in the use of extrinsic material. I think the textbook authors make the point well that it is a growth area where, if you think of that continuum I've mentioned in the past, we started with a very literal approach to statutory interpretation. That is, if you can't do it from the black letter law, then forget it. And we've come right along, and we're going to talk about extending it even further in the next couple of weeks, but we've come right along to a situation where we don't do that anymore. We do purpose, intention. We try to work out what the object of the legislation is. But there is a couple of provisos to that, and certainly in the legislation itself, in section 15A(b)(3), it talks about, just in short phrasing, it says, well, okay, just assuming it is allowed, what weight should we be giving to that evidence? Because after all, it is just evidence. I want to make that point to you as well, and we've done this before. These rules and what we look at are just possibilities. They're always just possibilities. So 15AB is saying, okay, well, we're going to bring in this extraneous material. We're going to have a look at explanatory memoranda. We're going to have a look at what the minister said. We might have a look at a dictionary, have a look at some of the surrounding cases. But remember, all of that is introduced as evidence by the counsel appearing for the parties, and it's up to the judge or the judges to weigh that evidence. And in addition, 15AB(3) says, well, all that process also has to add some value. And again, I think the point is well made in the text that if you do try to throw up arguments that really aren't ever going to succeed, you might end up with a costs order against you if it all comes to naught. Remember, though, that the list is not exhaustive, and also these points, again from your textbook, that the use of the internet even gives, well, the use of the internet in courtrooms and proceedings and what have you gives some pretty broad access to material that you might have had difficulty scratching up at short notice in the past. So, for example, even scratching up a copy of the Hansard or second reading to get the second reading speeches, or looking for the explanatory memorandum, they weren't readily available until recent times. Now they are extremely readily available, and I like that comment a bit of the way into Chapter 8 from Justice Kirby in Vannet against the Crown, where he said, as is usual nowadays, the court was taken to the second reading speech. So he seems to be quite comfortable with the fact that it seems to now be expected that there'll be a fairly broad-ranging look at what the context is. So what's the context for this legislation? What he does with it, of course, is another matter, because I don't want to be seen to be suggesting that Justice Kirby would do anything other than look at that material in accordance with the law. So you'd have to have some reason to go there. You still have to have some reason to go there. He does say, and he has said previously, that it's going to be a pretty rare case where you can't at least say there's some obscurity or some ambiguity about the possible interpretations of words which are used in legislation, particularly complex legislation which ends up in an appeal court. The couple of standout cases for me, but do have a look at the others that are in there, but make sure you do look at that Insurance Commission of Western Australia case. Remember, that was the one in Queensland we grappled for a long time with words to the effect by, through or in connection with a motor car. This was the one about whether you needed to be driving, and if you did, what did driving mean before you triggered the insurance. And the other one was the re Bolton ex parte Bean, because I think it's got a bit of both in it. On the one hand, it's saying, well, you can look at this material, that's fine, but the interesting thing for me was, having looked at it, the courts then said, well, okay, well, we've looked at it, but we're not going to use it because we don't think that there's a trigger there to use it, because the words on their face are pretty plain and clear, and we'll stick with the meaning that we're comfortable with, which is that this was really meant to be legislation that dealt with visiting forces, not people who were here illegally 20 years later. Look, they're my comments for this week. I don't think this is a bad read this week. I think Chapter 8 is well put together. As usual, concentrate first and foremost on this week's material before you then let your mind think about where this week's material fits into the scheme of things as we're building up an approach towards statutory interpretation. Thanks very much for listening.